The Honorable Justices of the Supreme Court, hear ye, hear ye, hear ye. All persons having business before this court are admonished to draw nigh and give their attention to the court.
Good morning. Welcome to council and to those who are watching us on our Kansas Supreme Court live channel. I would now ask Mr. Doug Shima, the clerk of the Kansas Appellate Courts, to please call the 9 o'clock docket.
Thank you, Your Honor. May it please the court. The 9 a.m. docket for Friday, April 2nd, 2021 consists of one case. Appeal number 121159, State of Kansas versus Andre Clark Rhoiney Jr. Shawnee County briefs both sides. The appellant has reserved 3 minutes rebuttal time. Your Honor, we're ready to proceed.
Thank you, Mr. Shima. Counsel, would you please enter your appearances?
Court, Michelle Davis on behalf of the appellant, Andre Rhoiney, present and ready for argument.
Good morning, Your Honors. May it please the court. Michael Duenas, Assistant Solicitor General, on behalf of the state, present and ready for argument.
Thank you, counsel. Ms. Davis, you may begin your argument.
Thank you, Your Honor. This is a case, it's a felony murder prosecution by the state. The state's evidence was that late at night, a minivan is driving down the street. There's a woman driver and a male passenger. And a motorcycle pulls up alongside and is weaving on the road. This leads to an exchange between the male passenger and the motorcycle driver that goes on for several blocks, where they're exchanging kind of fighting words. The motorcycle rider just became very agitated and they're talking back and forth. At some point, the van driver the woman becomes aware that there's an SUV following along behind the motorcycle. And at some point, as she's driving down the road, the motorcycle and the SUV pull alongside her. She said that 2 shots were fired at the van, and the male passenger in the van was killed as a result. The state's evidence, or the state's case, was basically the testimony of the woman van driver, and then also the motorcycle rider. And basically that Mr. Rhoiney was driving the SUV that was following behind the motorcycle, and the state claimed that he's the one that fired the shots. The defense in this case was that after the shooting, the woman driver was not really sure where the shots had come from. Although at trial, she said she believed they came from the SUV. She didn't observe the actual shooting or observe who fired the shots. And then the other defense was that police had arrested the motorcycle rider and that he was threatened with the murder charge. And it's at that point that he said that later, Mr. Rhoiney had told him that he had fired 2 warning shots. So that was the defense in this case. My plan here, we raised several issues in the brief. I'd like to really just focus on the first issue and submit the remaining issues, because the first issue is a little bit more involved. There were 2 trials here. The first trial, the state charged felony murder, reckless discharge of a firearm, an occupied vehicle resulting in great bodily harm to the passenger, and then also the aggravated assault of the van driver. And the 2 lesser felonies resulted in a conviction at the first trial. The state proceeded to a second trial just on the felony murder charge. And at the second trial, the judge gave the felony murder was based on the underlying felony of reckless discharge of a firearm at the vehicle, and the complaint had charged this was recklessly discharged. At the trial, though, the judge instructed the jury that if the state had proven that the defendant acted knowingly or intentionally, then the state had also proven that you acted recklessly. And the judge gave the definition of reckless, a conscious disregard of a substantial risk that the result would follow, but the judge did not define the mental states of intentionally or knowingly for the jury. And of course, this instruction was based on the recodification. Criminal discharge used to be an intentional act, And then with the recodification, when they brought in the 3 culpable mental states, it changed to reckless. And then they also brought in the statute that says, if you prove intentional or knowing, you also prove reckless. And so it's our contention that this created 2 problems. One is that the state had not charged intentional or knowing mental state, and so that the instruction was broader than what the jury was instructed on, in violation of Mr. Rhoiney's right to due process of law. And then second, that because the judge told the jury they could rely on an intentional or a knowing mental state, but the judge didn't define what those terms were for the jury, which creates a lot of problems. But the state tries to argue in this case that the jury could have used some kind of common sense understanding of intentional or knowing, which this court has found in some cases, but not in the context of the culpable mental state, which is defined by statute, because the legislature has given those terms very specific meanings. So for example, the intentional is that you, in this case, it would be that you do the act or cause the result complained about by the state. And so if you're going to tell the jury that they can find intentional or knowing conduct, because those terms are specifically defined by the legislature, you need to tell the jury what those terms mean, and that the failure to do that was error. In this case, too, the prosecutor told the jury that they could convict Mr. Rhoiney if based on any mental state, any of those mental states. And so the jury could have convicted Mr. Rhoiney. It's hard for this court to review that conviction. They could have convicted him based on their understanding of what intentional or knowing meant, which isn't necessarily what the legal definition is. So,
is there, counsel,
yes.
Can you help me? Maybe you can help by articulating how a juror might do what you just said, but that the juror's non-legal understanding of intentional or knowing would actually be a lower culpable mental state than reckless.
Yeah, Judge, I don't think it is, Your Honor. I don't think it is, if I'm understanding your question, I don't think it is a lower mental state.
Well, at law, of course, it's not. But
Right.
My understanding of your argument is, hey, there was no definition of there was no legal definition of intent or intentional given to the jury.
Mm-hmm.
So the jury might have convicted on their own personal understanding of what intentional means. That's your argument, right?
Yes, Your Honor.
And so I guess my question is, yeah, just how can you articulate a non-legal layperson understanding of intentional that's actually a lower mental state than reckless?
Yeah, I don't think we're trying to argue
Because
that.
I guess, well, then how is there any prejudice?
Well, it's a due process violation is what we're saying. That the jury, could have convicted him of something that he wasn't charged with. And also that it's almost like, I think we're comparing this to omitting an element of the crime in those neater line of cases that say it's a due process federal constitutional violation. By not instructing the jury on the legal definition of intentional, you're not accurately instructing them on the law and what the jury needs to find. So our argument is totally rooted in due process. And I'm relying on the Trotloff Kansas Supreme Court line of cases where they found that the jury could have convicted because the instruction was broader than the complaint. The jury could have convicted, in that case, the defendant based on elements that weren't charged.
In Trotloff, the charging document was broader than what the jury was instructed on. Here, that isn't the case, is it? I mean, that was the problem in Trotloff. How does this correlate with Trotloff? I don't understand. That was the case about a charging document.
I think the comparison I would give, Your Honor, and I understand where the court's coming from, I think, they say somebody was charged with a reckless killing. And then the conduct at trial showed that it may have been an intentional killing. So the judge decided to instruct the jury, you can find him guilty of this crime, whether he acted recklessly or intentionally. I think that's the problem.
How does that broaden the charge, though, when we have a statute that says they're equivalent? I mean, the phraseology I always use is the reckless is nested inside intentional.
Right. And so I'm not trying to say there's a legal error with that instruction. There was not. What I'm trying to say is once you bring this in, what that statute is basically saying is that anytime you charge reckless conduct, you're basically charging intentional or knowing conduct.
So but your argument, it seems to me, is your problem is with the lack of a definition.
And the lack of notice. It basically.
Is that really an expansion beyond the elements then? Or is it just a lack of a definition?
It's both. I mean, basically, once they brought that statute in that says when the legislature changed the statute and said it's reckless discharge of a firearm, and they also brought in a law that says anytime you prove intentional or knowing you prove reckless, they might as well just say the state might as well just charge knowingly, recklessly, or intentionally discharge a firearm at a vehicle. That's basically what the law is. And the state didn't do that. And then at trial, he's basically getting ambushed, which again, you're saying it maybe it's not prejudicial, but he's basically getting ambushed because now you're getting, like, you charge reckless killing, and now you're telling the jury you can find intentional is okay too. Basically, it's a different means. I mean, that was the problem in Trotloff, is they charged one means of committing the crime, and then they instructed the jury on a different means would be sufficient. So that's basically our contention here, is if the mental state element of the crime is important. If the state believes that its case is based on intentional conduct, then the state needs to be charging that, and the judge needs to be telling the jury what that means under Kansas law, because the mental state element is very specific under Kansas law.
But by operation of the statute, do you have notice? I mean, you mentioned that the state might as well list all three mental states in the charging document, but do they really need to do that because of the operation of the statute?
I guess if you have a good defense attorney, without a good defense attorney, no, or if you're proceeding pro se. But again, the idea of a charging document, I would think, is that it would be plainly apparent what the state is going to be seeking to do. So hopefully defense attorneys are waking up to this, but it's a new area of the law. So again, it still goes, I think, to the due process rights, and the state needs to be charging. If the state's with this law in effect, the state needs to be charging it. And if the judge is going to instruct on different mental states, then the judge needs to give those definitions. That's our contention. And I can see that I'm out of time.
Are there other questions? Thank you, counsel. Mr. Duenas.
Your Honors, may it please the court, I would comment just on that issue as well, and leave the others for questions if there are any. I think in response, first, just to talk about the Trotloff case, that case is distinguishable, as Justice Rosen mentioned, mainly because in there you had the charging document that was actually narrower than the instructions. So there they had charged that the defendant had committed the crime by displaying pictures, and that was the specific thing that the charging document gave. And then in the instructions, they listed about 10 other ways that you could convict. And that was also, the judge had noted that was the bulk of the evidence. A lot of the evidence was not on the displaying the picture. So there you did have a broader basis. And so the appellate court couldn't be sure whether or not they had convicted for displaying the picture or for several other things. And that was the basis there. Here, we don't have that situation. I think just by way of a historical understanding, as we've noted, there were two trials. In the jury instruction conference in the first trial, the prosecutor explicitly decided not to have, there was some discussion about whether to have an instruction on intentional and knowing, didn't do that. And so when you get to the second trial, that's really the only difference. I mean, the instructions were the same, except there was added in this instruction. And I think it's certainly possible that the jury in the first trial, again, there's no way to know for sure, but may have refused to convict on felony murder because it believed Rhoiney acted intentionally and not recklessly. And maybe they didn't know that one covered the other. And there seems to be some indication of that in the discussion in the record at the jury conference at the second trial. There they had the discussion of it, and the prosecutor explicitly says, this is a case where the jury can look at the evidence and determine that perhaps the defendant not only recklessly discharged his firearm at the vehicle, but intentionally did it. And so if it were the case that they believed that, they would satisfy the culpability for the underlying felony. So they were clearly aware of that issue, and I think that's why that was added. It was meant to avoid a hyper-literal understanding of the culpability instruction. And indeed, during the closing argument at the second trial, the prosecutor said, so this is not intentional conduct. So it was clear that in charging reckless conduct and instructing on that and giving a definition of that, that was proper, that was consistent with the complaint. And so this was added in, I think, just to avoid a hyper-literal understanding where a juror might have been confused and thought, well, I don't think he acted recklessly, he acted intentionally, and then believing they couldn't convict on that basis. And I would just agree with Justice Stiegel that reckless is kind of encompassed by intentional or knowing. If you've proved those, as the statute says, then you've proved reckless. I would just, I guess, finally add that this court said in State v. Bartlett clearly that the legal definition of intentional is essentially the same as the common meaning of the word, which would be familiar to the lay jury. So there really isn't a need to provide an explicit definition. Indeed, an explicit definition is only required if the instructions as a whole would mislead the jury. That was State v. Armstrong. And so I think here, that's why that was avoided. But there certainly was no prejudice. I think Rhoiney seems to concede that. I don't have anything further unless there are other questions. I'd be happy to stand on the brief.
Any other questions?
From the state's perspective, do we reach the merits of each of the defendant's claims of error? Or are you making a preservation claim on any of them?
Well, we did make, I would make a preservation claim. The one I have, at least explicitly in my mind, would be on the fourth issue, the identical offense doctrine, that I think we said based on State v. Gray and State v. Buckschrog, that those aren't reviewed or those aren't preserved. And it's similar to those cases. So I would just urge the court not to reach the merits on that one in particular, just given the way the court ruled in those two cases.
And just to be absolutely clear, is that because from the state's point of view, these issues were raised for the first time on appeal?
Yeah, they were raised for the first time on appeal, and they don't go to imposing or challenging the classification, just the district court's authority. I mean, it's the same rationale, but yes, because they were raised on the first time on appeal.
Any other questions? Ms. Davis?
Thank you, Your Honor. I believe that I fully argued what I needed to argue, so I would waive rebuttal unless there are questions from the court.
I just had a couple preservation type questions,
Okay.
if I may. The first is just to ask what the defendant's perspective is on what we just heard from the state about preservation on the identical offense doctrine.
Yeah, I think I would have, based on the recent decisions by this court, I would have to rely on the basis in my brief that the exception applies, that this is an issue of law strictly, and that resolution would decide the case. I would have to rely on that exception.
On the jury instruction claims of error, what is your view of our standard of review on those?
On the failure to give.
I'm sorry, go ahead.
On the failure to give the lesser included offense, That would be the clear error standard because it was not requested below. On the failure to instruct the jury on the law, again, I'm going to the federal constitutional harmless error standard as a matter of due process of law.
Okay, so that's an interesting question, which since we have a little time, I'll explore with you. It sounds like you're not actually raising a jury instruction error claim. You're raising a general due process claim. And doesn't that have to be preserved below?
I think I raised it as I think I raised both of these together, the failure to charge, that the failure to charge and then the failure to define the elements. And so I put those together as one big due process problem. So
I guess, could you articulate from again, your view of where that stands on appellate review from a standard of review preservation? Because if this was a typical jury instruction claim, this would just be clear error, right?
that's correct.
But you're kind of, but you want to proceed on a slightly different basis.
That's true. I mean, I am making this as a due process claim, and I think in my brief I put.
So does that change the preservation requirements below?
I claim the exception of question of law, and
Okay, so
right. I went with Trotloff and the fundamental right.
So you're here saying that essentially we admit that this was not preserved, and we are asking for one of the exceptions so that we can raise this for the first time on appeal. As opposed to, hey, this is clear error, this is a jury instruction error, and review it for clear error.
That's correct. That's how I raise this issue.
Thank you.
I would conclude my presentation, Your Honor.
Okay. Any questions? Doesn't appear as such. So thank you to both counsel for your arguments today. We will take this appeal under advisement. The court is in recess until 11 a.m. this morning.